and it is my great pleasure to welcome you to the 9th Annual Frank M. Coffin Lecture on Law and Public Service. This lecture has always been one of the high points of the academic year at the University of Maine School of Law. It is also a great honor for me to have the opportunity to meet and to present to you our distinguished lecturer, Alan B. Morrison, and to introduce as well Judge Frank M. Coffin, the distinguished jurist and public servant par excellence for whom this lecture is named. We are also pleased this evening to welcome Mr. Morrison's wife, Anne, the family members of Judge Coffin who are with us this evening, Mrs. Ruth Coffin, and their daughters, Meredith and Nancy, Professor John Sims, a former clerk to Judge Coffin and a professor at McGeorge Law School in California who traveled on the red-eye last night to be here, and many other of Judge Coffin's clerks who were, as a group, so instrumental in making this lecture series a reality. The University of Maine School of Law takes great pride in its sponsorship of the annual Coffin Lecture. The lecture reflects and celebrates the law school's strong and abiding commitment to public service and challenges us to consider new ways to ensure that law and the legal profession continue to serve the public good. The law school itself has a long record of public service to Maine, to New England, and the nation. The law school's faculty and students provide valuable public service through the Cumberland Legal Aid Clinic, which provides legal services to low-income Mainers, through the Marine Law Institute, the Garbrick Law Library, and various student organizations such as the Maine Association of Public Interest Law, which raises funds each year to provide stipends to students who render legal services during the summer for little or no compensation. And there may be some at Public Citizen Litigation Group. Excuse me. Since its inception in 1992, the Coffin Lecture has brought to our community a brilliant array of extraordinarily talented and thoughtful individuals. From Ole and Michael Rao and Justice William J. Brennan, who delivered posthumously the remarks of our first Coffin lecturer, the late Joseph Rao, Jr., to last year's Supreme Court Justice Ruth Bader Ginsburg, who was our 8th Coffin lecturer. Each of the Coffin lecturers has challenged us to reflect in new ways upon the powerful intersection of law and public service. And there is no doubt whatsoever that our 9th distinguished Coffin lecturer, Alan Morrison, will continue in that fine tradition. As Judge Coffin and I have divided our responsibilities, I am to provide you with a biographical introduction of Mr. Morrison, and Judge Coffin will characteristically provide the depth and the substance. The Legal Times has called Alan Morrison, quote, the man to turn to when you want the best to argue the big ones. In this case, the big ones are important cases before the United States Supreme Court. Landmark cases like Goldfarb versus Virginia State Bar, which struck down lawyers' minimum fee schedules. Maybe some of us have concerns about that. Virginia State Board of Pharmacy versus Virginia Citizens Consumer Council, which brought commercial speech within the protection of the First Amendment, and Boucher versus Sinar, striking down the Graham-Rudman Act on separation of powers grounds. Mr. Morrison has been arguing and preparing big ones since 1972, the year in which he founded, with Ralph Nader, the Public Citizen Litigation Group. Under Mr. Morrison's leadership, the Litigation Group, which is one of the nation's preeminent public interest law firms, has brought many precedent-setting lawsuits on behalf of citizens to protect the health, safety, and rights of consumers, to further workers' rights and tobacco control, to make government more transparent and accountable, and to defend the constitutional separation of powers. Within the last decade, the Public Citizen Litigation Group has expanded its reach through the Supreme Court Assistance Project, which provides invaluable help to lawyers handling important cases before the Supreme Court who have little or no prior Supreme Court experience. Alan Morrison received his bachelor's degree from Yale College in 1959. After a stint in the Navy, He attended Harvard Law School, received his law degree magna cum laude in 1966. At Harvard, he was a member of the Harvard Law Review. After graduation from law school, Mr. Morrison practiced law in New York City, first with the law firm of Cleary, Gottlieb, Steen & Hamilton, and then for 4 years as Assistant U.S. Attorney for the Southern District of New York. In 1972, Mr. Morrison left New York City for Washington, D.C. and Public Citizen, and the rest is history. In addition to being a renowned appellate lawyer working in the public interest, Mr. Morrison is also a prolific legal scholar. He is the author of numerous scholarly articles and books, just a few of which are listed in your program. Mr. Morrison has been a visiting professor at the Harvard Law School, an adjunct professor at NYU Law School, Stanford and Tulane University, and a lecturer at Fudan University in Shanghai, China. He is the president of the American Academy of Appellate Lawyers and a member of the Program on Science, Technology, and the Law of the National Academy of Sciences. He is currently on the board of directors of several foundations and of the District of Columbia Appleseed Center for Law and Justice. In 1995, Mr. Morrison was the recipient of the William J. Brennan Jr. Public Service Award given annually by the District of Columbia Bar Association. This is just a brief summary of some of Alan Morrison's numerous achievements. The real introduction, however, the one that enlightens and deepens our understanding of the Coffin lecturer, will be given, as it always is, by another exemplar of a life devoted to law and the public service, the individual for whom this next lecture is named, Judge Frank M. Coffin. I have a few things to say about you as well. Judge Coffin, as we know, is one of the very rare breed of public servants. As I have said before, he is one of the few people who has served with distinction in all 3 branches of our government: as a U.S. Congressman, in the executive branch as Deputy Administrator of AID, the Agency for International Development, and in the judiciary. First appointed to the U.S. Court of Appeals for the First Circuit in 1965, he served as its Chief Judge from 1972 to 1983. In 1986, he assumed senior status on the court, and as all of us in Maine and throughout New England know, that has not slowed him down one bit. It has been a great privilege for me as the Dean of this law school to get to work with Judge Coffin, and it's a great honor to our law school to both present this lecture and to have him as a friend. As one more thing. As then Senator William Cohen, now Secretary of Defense, said on the occasion of the unveiling of Judge Coffin's portrait at the Chanute Courthouse here in Portland, "If a fair measure of the man is whether he has made a difference, you could have rested long ago." Fortunately for us, Judge Coffin has not rested, and it is my great honor to present him for the real introduction of Alan Morrison. Thank you.
I really don't know how many more of these I'm going to be able to stand. Chief Justice, former Chief Justice, former Dean Godfrey and Dean Zillman, Dean Corey, members of the faculty, judges, friends, lawyers, human beings. We're happy to be here once again. You know, it is reliably said that a cat has 9 lives, and we can now hold our heads up with the cat as we approach our 9th Coffin lecture. But there are weightier reasons. As Dean Corey has pointed out, we've had a number of very well-respected people at the top of their profession who have invested their time, their wit, their wisdom, and something of their life in coming here to this forum. But no one can come closer to the concept of the linkage between the practice of law and public service than tonight's speaker. He represents the complete, stripped down, unvarnished, no frills, bells or whistles, rock bottom law and public service career. You've learned a little bit about his vitae, his schooling. It was all very respectable. Then he followed not particularly the primrose path, but one of cuckleburs and thistles, and seems to have thrived on that. He did serve, after leaving the prestigious firm of Cleary Gottlieb, he went off the deep end a little bit by joining up with a legendary figure, Robert Morgenthau, then a U.S. attorney, and who is still a very important district attorney in New York, causing all sorts of trouble. Our speaker is still remembered in those precincts for a tax fraud trial when he had a witness on direct examination, and suddenly the witness slumped over and died from a heart attack. Now the story, perhaps apocryphal, goes that as the body was being removed, Morrison confided to a colleague, "You should have seen my cross-examination." But then he went on to join another legendary figure, still enduring, Ralph Nader, to form the Public Citizen Litigation group. What is this group? It is a deliberately small enclave of about 10 lawyers, public interest lawyers, top of the mark litigators, who, despite Spartan pay and accommodations, stay on and on with the group for extended periods. It occupies a unique niche. Now, there are many other watchdogs, gadflies, and ombudsmen, but this group has carved out a unique role for itself, not wholly by accident. One of the idiosyncratic facts about our speaker is that tucked inside his wallet is an old, tattered and torn piece of paper concerning the aspirations he had for this group at the moment of its inception. And without detailing the cases, let me list what I discern as the unique and defining characteristics of his group. One, it begins with citizen participation, which is not surprising under a public citizen aegis. But a lever for achieving citizen participation is openness of government. And a lever of achieving that is the Freedom of Information Act, which he has used on many occasions. Another key element in the essence of this group is monitoring regulatory agencies so that they act up to snuff, so that they follow criteria, rely upon a proven record, and engage in rational decision-making, whether it be in automobile safety or nuclear power. A third key element is opening up the legal profession and improving access to justice. You've already heard about the Goldfarb and minimum fee case. Right now we in Maine, who are involved in our efforts to improve access to our courts, are hoping against hope that their efforts in sustaining the viability of IOLTA funds, lawyers' trust funds for legal services, will be successful. Consumer protection is another field where, in various cases, he has almost written a consumer bill of rights. Union accountability, Teamsters and others. Policing the three branches of government, which might not seem necessary, but it certainly has proved useful, because the public interest group brought about the end of President Nixon's impounding of funds which Congress had rightly or wrongly ordered to be spent. The Chadha case spelled the end the death of the legislative veto, which was often abused. And the most recent victory was declaring the line item veto unconstitutional. Well, the unifying theme of all of this, it all adds up to, in my mind, the objective of assuring the proper running, maintenance, and repair of our basic governmental and communal structure. And you can't underestimate the influence. They have argued over 40 cases in the Supreme Court. This constitutes roughly half a year's work doing nothing else but handling those cases. But they're not just cases. They are seminal cases that are chosen for the significance of their impact. And 60% of these cases have been won. So if one is really looking for the vitae of our speaker, we can make the same reply that was once made concerning Christopher Wren, the celebrated architect of St. Paul's Cathedral. If you seek his monument, just look around you. Now, all of this is somewhat formidable. Is there a human being underneath? I have been invoking my own Freedom of Information Act to penetrate the public facade. The first quality I have discovered is not very private. It is Alan's incredible energy and production. He works hard and fast. This afternoon he was on a conference call. What was he doing? He was judging a trial moot court argument at Georgetown Law School from Portland, Maine. He plays hard and reasonably fast. He has the gumption, or perhaps the foolhardiness, to participate with a number of rather irrational creatures like Dean Zillman in tomorrow's road race. I am told that passers-by on Connecticut Avenue in Washington are often diverted by seeing Alan on one of his runs from downtown to Cleveland Park. The second characteristic is generosity toward colleagues. Working with a young lawyer on the latter's first attempt at writing a brief, he will say with a deep breath, "This is salvageable." With more experienced colleagues, he will never just say, "This is bad." He will always have ideas to improve it, and he will not hog the limelight or in any way cut down the colleague. A third quality is commanding presence in court. He is the kind of advocate with a track record that enables him to take charge, to say to a questioning bench, "Your Honor, in addition to those answers, another answer is that that's the wrong question." He is, in short, the kind of advocate to whom judges give considerable slack before they rule against him. Now, looking for similarities between our speaker and myself, I was glad to find one characteristic that we shared. We both write microscopically. I do because I have no confidence that anything I say in a first draft has any merit whatever. I suspect that is not Alan Morrison's problem. In any event, I understand that at one time his colleagues, faced with deciphering one of Alan's memos, inter-office memos, resorted to cutting out some commentary, posting it on the office bulletin board, and inviting people to try their hand at translating. Even Alan, a week later, would try and fail. Without further ado, let me proudly present our 9th Coffin lecturer, the legendary Alan Morrison.
It's really a great pleasure to be here, and not only because of the very kind and more or less true words that were spoken. I really do appreciate it. I want to acknowledge my colleague, John Sims. I was prepared to say how pleased I was that he was here. I didn't realize that he was going to be the leading source for most of those stories. John is an example of one of our short-term colleagues of the litigation group. He only lasted 11 years. We always like to say that the people stayed so long, and it didn't matter that we weren't paying him any money because we were working them so hard they had no time to spend it anyway. It's also a great honor to be here. The list of prior speakers, Justice Brennan, my friend Joe Rao, Justice Ruth Bader Ginsburg, Senator Rudman, John Schlesinger, Arthur Schlesinger, recalls in my mind a similar event when I was asked to speak. The Harvard Legal Aid Bureau had its 75th anniversary in 1988. Justice Brennan had spoken at the 50th anniversary, and he was invited back to speak again, and he had accepted. Unfortunately, in the several months before he was scheduled to speak, he developed a bad case of shingles, and his doctor said to him, "You certainly should not travel or do anything more than you have to do. You're active on the bench, and you should stay there and not travel to Boston." So he called and said he couldn't come, and they tried Justice Marshall, and he declined. They tried Justice Blackmun, and he declined. And I had been on the Legal Aid Bureau, and the executive director of the Bureau called me and said to me, "We want you to come and speak." And I said to him, it reminded me of the story, football story about Y.A. Tittle was traded from the San Francisco 49ers to the New York Giants for an obscure left tackle named Lou Corteleone. And when Corteleone was called by the press to comment on the trade, he said, "Just me?" And that's the way I felt both in 1988 when I gave the lecture for the Legal Aid Bureau, and again here today. There was a particular challenge in giving this lecture, and that is I had to give my topic in advance, which meant that I actually had to think about what I was going to say and give a topic a month or two in advance, which is far beyond anything that I usually do. And now, of course, I've got what I was going to say, I fixed the title, and now I have to figure out how I'm going to put all the thoughts into the title to see whether I can actually deliver on what I promised. I want to say a word about the Public Citizen Litigation Group and some of our activities because it bears on what I'm going to talk about here today. But I do have to make one small confession, and that is the little yellow piece of paper which was in my wallet may still be in my wallet, but unfortunately I was in the hospital in Austin, Texas recently, having had an unfortunate kidney stone attack, and while I was in the x-ray room someone took my wallet, and I didn't mind the credit cards, I didn't even mind the money too much, but this little yellow piece of paper meant something that could never be replaced. In any event, it's been a wonderful time at the litigation group. One of the things that we did when we started in 1972, and I really thank my boss, Ralph Nader, for essentially giving me free rein to do pretty much what I wanted to do. And one of the things that he and I agreed needed to be done was we needed to look at the legal profession, because nobody was looking at the legal profession to see whether legal services were as affordable and available as they should be. And we knew that things needed to be done, and so we set out on a list of topics. The minimum fee schedules, we were successful. We wanted the advertising rules that prevented dissemination of information from going out to the clients. We went after those. Residence requirements for bar admission, restrictions on group legal services, rules against the unauthorized practice of law, and secrecy in the bar disciplinary process. In my view, all of these particular activities shared one element in common, and that is that the rules were made by lawyers for the economic benefit of lawyers, or at least for those lawyers who made the rules. They were, of course, approved, the rules were approved by judges in some or in many cases, but not all. Judges, of course, had no particular economic interest in the outcome, but they were, of course, all once lawyers themselves. They had many friends who were lawyers, and in some cases, not the state of Maine, judges get elected and re-elected, and their principal supporters in the re-election are none other than lawyers. So they can never be fully divorced from the lawyers. And of course, when the rules would come up to the courts, in many cases, they would not be looked at with any kind of care at all. There were several states that had a rule that any change that the American Bar Association recommended were automatically adopted by that state. I'm glad to say that those kind of rules no longer exist, but they were certainly the norm back in 1972. And at least when these matters came to the judges, if the bar didn't point out that there was a problem with a rule, most of the time nobody else paid any attention to them. So we set about a systematic effort as one part of our work to change the legal profession. Whatever else you can say, there clearly have been major changes in the legal profession since 1972. I leave for others the question of whether we are better off, but I do know that there is still a long way to go before we achieve the goals of affordable and available legal services for all Americans, and not those at the very top or the few who can fit into the legal services programs at the very bottom. This evening I want to look at the legal profession from a somewhat different perspective. And that is, the fundamental tenet of the profession is that the interest of the client comes first. Often this is said with regard to the client's relation to the lawyer, so that if the client wants to settle a case and the lawyer doesn't, the lawyer has no choice. Sometimes it'll be a dispute over whether the case should be settled because there's enough money there or not enough money there, and sometimes it'll be a matter of principle or not a matter of principle or a matter of dollars. Or sometimes the client wants to settle a case, that doesn't want to settle the case, and the lawyer does because he thinks that the client is going to lose, and the lawyer is thinking about his own fees. Most of my focus this evening is not on that kind of conflict, but rather the relation between clients and other people. In particular, I want to examine situations where the lawyer's duty to the client may cause injury, serious harm to third parties. I'm going to begin with the case of a New York attorney named Frank Armani. Most of you have probably never heard of Mr. Armani, but you probably will, some of you will certainly recall his story. He occupies roughly 20 pages in a quite interesting book that I read last summer called The Moral Compass of the American Lawyer, written by Richard Zittrain and Carol Langford, who are lawyers and teachers of ethics in San Francisco. Under a series of circumstances, Mr. Armani, who had previously represented a man named Robert Garrow, agreed to represent him again on a charge of murder. In addition to the single charge of murder in which he was then under indictment, Mr. Garrow was suspected of having killed at least 2 other young women. The problem was they had no proof, and in fact there were no bodies for these 2 young women that had yet been discovered. During the course of representation, Mr. Armani and his co-counsel learned of a series of facts from which they discovered the location of the 2 bodies of the young women. Turns out that it was quite difficult to locate these bodies, even if you knew where to look, and the person who had caused the deaths had gone to considerable trouble to be sure that you wouldn't find the places to begin with. The question they faced was, what could they and should they do about this information? The families were very concerned, wanting to know whether their daughters were still alive, and of course, Mr. Armani and his co-counsel knew the answer to that question. Assume for the moment that they had actually learned the location of the bodies from their client. There can be no doubt that under the attorney-client privilege, as embodied in all of our ethical rules, that they were forbidden from disclosing that information. Well, suppose that they actually had not learned it directly, but simply by inference. They then located the bodies, as in fact with more likely the case here, based upon their own investigation. They're not revealing what their client said to them, so they're not technically violating the attorney-client privilege. Does that change the outcome in any way? Well, where does the attorney, one begins by asking, where does the attorney's duty lie? And it clearly lies to the client. Would disclosure be good for the client? Well, why don't you ask the client, one would say. How do you feel if we tell the police where these bodies are buried? Think about the families, after all. They really want to know. You'll feel better if you tell them that. The client says, right, probably, think about my body and think about what's going to happen to me. Well, suppose we try to bargain with the prosecutor. Perhaps we can tell them where the bodies are, trade information for leniency. This, of course, is a rather difficult trick to pull off without telling them what you know before you start to bargain with them. And, of course, Mr. Garrow was already the primary suspect in these murders anyway, so by telling him where the bodies were buried, the connection would be even more obvious than it was, besides the fact that you are, after all, the lawyer for Mr. Garrow to begin with. Could they tell the judge, or could they tip off the newspapers? All of the same kind of dangers lurk behind. So they didn't say anything. And subsequently, the bodies were found, and before Mr. Garrow's trial took place, they were known and the location was known. Mr. Garrow testified at trial about the actual murders because his principal plea was an insanity defense. So one could say, well, it all turned out all right in the end. Nothing seriously happened. Except that's not quite how it happened to Mr. Armani. Because while he was clear that the rules on ethical conduct commanded him to do what he did, the community didn't feel that way at all. They didn't think that lawyers should be doing things like this, or more precisely, not doing something that the community thought that he should do. The Code of Professional Responsibility in 1973 really gave them no choice but maintaining their silence. The Moral Compass book has a long description of a series of events that I won't take the time to go into with you today. Some of these problems that they encountered were at least partially self-induced, but to call it a negative reaction in the community would be to vastly understate the feeling toward Mr. Armani and his ability to continue as a lawyer and as a member of the community in a small upstate place. In the Garrow case, by the time that the attorney learned of the two bodies, the two women were already dead. But suppose now that Garrow tells Mr. Armani that yes, he did assault them, but he believes that they are still, or may be, still alive. And not much longer are they likely to live. Can he tell anyone in that situation? At the time of the actual events, the answer was pretty clearly no. The answer today is, in some states, a lawyer is permitted to give that information in order to save human life. In others, the lawyer is still not permitted to give that information unless the client consents. And in no state of which I am aware is the lawyer obligated to provide that information to the public. Now, I would be willing to bet that if you asked most people who are not lawyers, they would come up with some rather different answers than the answers that lawyers came up with in that situation. I want to change my hypothetical around a little bit further. Suppose that we have a client who has placed a bacteria in the water system of a community. It turns out that the bacteria is not deadly in the sense that no one is likely to die from it, but that lots of people are going to get sick and be very unpleasant health for a period of time. It's already done. There's no way to stop it from happening. But there are ways that if the city water department knows about it, there are things that they can put in the water system to reduce the impact or use other sources of water for the time being. unless the lawyer determines that there is serious bodily injury that's likely to occur, the lawyer is forbidden in every state from providing that information. Or to take an even more poignant example, suppose you are a lawyer in a divorce proceeding and the issue relates to child custody, and your client tells you that the client has been abusing a young child who is his child. And the question is, are you permitted to tell anyone about that when the client tells you that he has reformed and that he has not done anything wrong in 3 months and will never do it again? The answer, again, is the same. The lawyer is forbidden from doing it. On and on through economic crimes where the answer is even clearer. And the only thing that you can stop someone from doing is preventing death in some cases, or if the lawyer is asked for advice about committing a crime, the lawyer could be considered to be part of the criminal activity itself, and the privilege would not apply. Now, before our outrage gets the better of us, I want to ask, are the results in all of these cases under the code wrong? Or more precisely, are they clearly wrong? Surely most lawyers would say, oh, these are difficult problems, but the attorney-client privilege is a very important privilege. And lawyers would also say the Sixth Amendment to our Constitution guarantees the right to effective assistance of counsel in criminal cases. And if you change these rules, that would seriously undermine both of those constitutional and common law rights. Do those lawyers who would say those things have a point? Are those values important values? My answer is yes. There is a point, and the values are important ones. But the question is, are those the only values that we ought to be concerned about? And broadly speaking, whose values are those? Those are, I suggest to you, principally values that the lawyer sees in his or her own professional outlook. They are values that give added importance to the lawyer and to his or her role in the profession and in society. It is, of course, perfectly natural for lawyers to have that viewpoint, and they should view their profession with importance and take a position strengthening the profession. But the question I want to ask is, does that or should that make the rights of lawyers controlling in these situations, or does the outcome correct simply because lawyers think it is so? On the other hand, there are clearly interests on the other side beyond protecting the interest of the client. Those interests are obviously recognized by those states that at least permit lawyers to make disclosures in some circumstances. In those cases, the state, principally the state Supreme Court, has struck a somewhat different balance than other states have struck. It is surely not unthinkable that the examples I have given to you could come out differently, and that we would still have our basic adversary system. We would still have zealous representation, but it would be within a different set of limits than we now have. I want to shift now from the criminal side of the law to civil cases, and I want to talk about a current situation which we've all been reading about in the newspapers and hearing on television, and that is the controversy surrounding the Firestone tires and the Ford Explorer vehicles. Lots of lawsuits have been brought about the dangers of these two products. I assume at the beginning that the defendants' lawyers are sworn to silence, and I won't try to deal with their particular responsibilities and problem. But what about the plaintiffs' lawyers? They don't have an attorney-client privilege. After all the information that they're learning from the defendants and from other people. So they are not prohibited from saying anything to regulators or anyone else about what's going on. That, of course, leads us into the wonderful world of protective orders. Let me explain. In a lawsuit, the plaintiff asks for some documents. Says that they are clearly relevant, as they are. They're essential to the case, which they are. And the defendant says, oh, these are trade secrets or they're commercial information and you can't have them. Confidential, and they're of great value to our competitors. But the law recognizes that in general there are privileges that preclude disclosure of that kind of information. And leave aside for the moment the question of whether the extent of these claims are proper. There are likely to be some things which may well be confidential and otherwise be protected. So the defendant says, well, I realize that I can't keep the plaintiff from getting the documents necessary to prove the plaintiff's case. So you, the plaintiff, can have them, but you're under what's called a protective order, which means you can't divulge anything that you learned from me, from our documents, unless you get the court's permission to do so. Or the court orders it to be able to be made public. You may also only use it in litigation, and if you want to use the documents, you have to file them under seal so that members of the public cannot get access to them. This, of course, applies to everything you learn in the lawsuit, so that when you take the depositions of our witnesses, those depositions all become sealed as well. And of course, it applies to all of your staff, your co-counsel, and your expert witnesses. And it applies to everything we turn over, because we don't want to bother all the time to figure out which things are really confidential and which things aren't. Does the plaintiff, or I should say more accurately, the plaintiff's lawyer, really have much choice in that situation but to go along with the protective order? These documents are essential to prove the client's case. They could claim that they're not privileged. They could at least make an argument on that account, but that would take a very long time. There would be lots of money. The client would not be any better off. And by the way, the lawyer, of course, wouldn't get paid in the meantime until the client's case goes to trial or gets settled. In the end, even if they got everything with no restrictions on the use, that's not likely to be a long and not very fruitful battle. So the plaintiff's lawyer agrees and takes everything under a protective order. And sure enough, the documents turn out to be dynamite. The depositions turned out to be even better, because he's got the documents and the witnesses who wrote the documents, and he gets everything he wants, all of which, of course, is under seal. The defendant at this point decides, I think I better settle this lawsuit. Things are not looking very good, and offers the plaintiff a very large amount of money. Indeed, the lawyer, and this is actually a case involving Firestone, the lawyer said to me, much more than my case was worth to take this settlement. But there was, you see, this one condition, which is that you have to give back to the defendant all the documents that you had to begin with. And you can't reveal them until to anybody else what you learn. The first question is this a legitimate role for the defendant's lawyers to play? And the answer is, I think we would all say that under our current system, the defendant's lawyers can properly do that. Is it unethical for the plaintiff's lawyer to accept that kind of offer? It is clearly an offer in the best interest of your client. And if your job is to represent your client and do the best you can for them, how can you not accept that offer? Because it's clearly in the best interest of your client. Suppose the lawyer, however, were to say, well, I don't want to accept this secrecy. I don't believe in that secrecy stuff. It's too important. I'm not going to accept the secrecy. So the defendant will say, that's all right. You can have non-secrecy. We're going to cut 2/3 off the price that we're willing to pay to your client. I suppose in the real world, of course, the defendant would never have to say that, because the plaintiff understands that the secrecy is part of the bargain. Well, at least the plaintiff's lawyer asks, what about other cases that I have? Or other cases that other lawyers have? The defendant says, well, if the lawyer asks for the documents, I'll be glad to give them to him. If they know what to ask for, of course. The defendant's lawyer doesn't quite say that. And the plaintiff's lawyer says, well, what about other victims? The defendant assures the plaintiff's lawyer that this is an isolated case, that it really, we're just keeping these secret because we don't want all this bad publicity to get out, and there's nothing really wrong with it. And besides, we've taken the product off the market, made some changes so it won't happen again. Bringing it up to the present time, of course, the last statement about the Firestone tires is clearly no longer true. It is not an isolated problem, but there are tens, scores, hundreds, who knows how many people have been injured by them. And what about the protective order which was in existence? Should the plaintiff's lawyer continue to agree to these protective orders knowing that there are other victims out there? Is there somebody else who needs to know this information? What about the agency, the National Highway Traffic Safety Administration? They, of course, have subpoena power. Their problem is that they don't know what to ask for. They've got a limited budget, too many other fish to fry, and so they are in a very difficult situation. The lives are clearly at stake, and yet, under our system of ethical rules, the plaintiff's lawyer continues not to have any choice but to say, I'll take the money from my client and I'll give you back the secrecy instead. The rules are pretty clear on that the client is the boss and the lawyer must do what the client wants. Of course, the client could say, the secrecy be damned, the money be damned, we're not going to take this secrecy order. But there are very few clients who are willing to say that. And the defendants do have a point about trade secret materials, bad publicity, and other things. The question again is their point controlling? Should it be the answer to the question that zealous representation is enough when once again we have substantial interest of third parties who have no say in this litigation? Are they going to be harmed by zealous representation by the lawyer? Or take another case where defense counsel takes an aggressive but plainly ethical position by representing clients zealously. The facts are from a 1986 Supreme Court case called Evans against Jeff D. This was a class action against the state of Idaho over the treatment of disabled children. The plaintiffs were represented by a public interest law firm. The clients had no money to pay anyone any fees. The only fees that they hoped to get were from the state if they won under a statute that authorized fees to be paid. The court decree will not provide any money but simply equitable relief, changing the conditions under which the children are being taken care of. The defendant offers to settle the case and offers to give everything that the plaintiff could have ever hoped for in terms of equitable relief. But there's one condition, that the plaintiff has to waive the right to attorney's fees. The plaintiffs themselves, of course, don't care about attorney's fees. They weren't going to get them. They're perfectly happy with the relief. The lawyer has no choice because the client interest comes first. The lawyer attempts to sign the agreement and then challenge it as unenforceable, as unethical. The lower court held it was unenforceable, and the Supreme Court said no. They said there is no law that forbids a defendant from making that kind of request. There's no ethical prohibition against it. And the lawyer is stuck in that situation. Is it just the fees of the lawyers we ought to be worried about in this particular case, or is there something else at stake? Think about it for a moment. If this is the law, what it's going to say to other lawyers who come along in the future and say, well, I might want to take this case, but if I know that the defendant at the end can offer my client everything, and I have no choice as an ethical lawyer but to agree to that settlement, but lose all of my fees, I know what the answer to the question is when I'm asked to take on a case like that. And that is, I won't do it. And I won't do it because as an ethical lawyer, I have responsibilities to myself as well. So the real loser in these situations is not going to be the lawyers, because the lawyers just won't take the case on. The real losers are going to be the next set of clients who are injured by the perfectly ethical conduct of defense counsel in the first case. Lest anyone think that all my objections apply only to defense counsel, here is an example of something from the other side of the table. In class actions, as many of you know, you are forbidden from settling a case without the approval of the court. This applies to both the merits of the settlement and to counsel fees. The rules are there to protect the class members from having their cases sold out by class representative, or more likely, a lawyer for the class representative. In many cases, there are objections to class action settlements, and I want to make a disclosure here. Our office is regularly an objector. We refer to us sometimes as officious intermeddlers, or I should say, that's what the class counsel think of us as most of the time. In some of these cases in which we and others object, there are not simply legitimate objections, but they're actually quite compelling objections. On the other hand, in a number of cases, the objections are, to put it charitably, dubious or thin. Since the plaintiffs and defendants are by definition happy with the settlement, after all they've agreed, the objectors are seen as spoilers in cases like this. In a class action, only members of the class are permitted to object to the settlement. In many of these cases, their interest is quite small, a matter of a few dollars, but many of the class members object as a matter of principle if they see a sellout, even though they're not going to get very much money. And lawyers, some of them oppose class settlements as a matter of principle, but some of them, the matter of principle is less important than the matter of fees. And they have learned that by objecting to class settlements, they can get paid off, or more likely, more properly put it, bought off, since their objections are leveraged to prevent the settlement from going ahead. In a typical scenario, the objectors are filed, and the class counsel comes in and buys them off, literally paying the lawyer out of class counsel's own fees, which they now have to decide when they set the amount of the fees. They build in an amount knowing that they're going to have an expense known as buying off objectors. They, of course, will deny that this is the case, but once you understand the mechanics of this situation, you'll see it's almost inevitable. The class counsel are supposed to represent the class. They believe in buying off these objectors. They are, because they think the settlement is a good settlement. They're going to get the money sooner. They, of course, are going to get their own fees sooner. So they're perfectly happy. They're zealously representing the interest of their client and assuring that a good settlement goes through, and it goes through sooner rather than later. Sometimes these payoffs occur, or agreements to pay off occur, before the notice goes out to the class. Sometimes not until after objections are filed, which are then withdrawn. Sometimes there are some cosmetic changes made in the settlement to justify paying the fees to the other lawyers, but not always. The case became particularly poignant with two situations in which district courts approved settlements, and while the cases were pending on appeal, the objectors settled their cases and disappeared, and the case went forward. It's unclear in these cases whether it was the defendant or the plaintiff counsel who actually paid off the objector. In my judgment, although the reasons for them doing so are different, there are similar problems in both of them. In the first case, there was a legitimate, and since it was our office that was involved as co-counsel but not lead counsel for the objector, a compelling argument against the settlement. In fact, the Supreme Court ultimately decided a case under which, if the settlement could not have been approved as a matter of law because it violated Rule 23. It was an important legal issue, and counsel went to our lead counsel, that is the client, the counsel who actually had the personal representation of the individual, offered to pay substantially more than the client would have gotten in the settlement itself. Money was also paid to the lawyer as well. There was no court approval, there was no disclosure, and since we were co-counsel, there was nothing that we could do about the situation ourselves. In the other case, the objector who was bought off had filed plainly frivolous objections. They had received the back of the hand by the district court. And the only reason that the company or the plaintiff's counsel paid off the objector was to get rid of the case. Defense counsel may well have considered that the cost of defending even a frivolous appeal was going to be more than it was going to be worth it to pay the objector off. The objector was paid off, and this time we didn't represent the objector who was paid off of the client. So we objected and said the matter had to come before the district court, and the district court had to have full disclosure, just like class counsel would have had to, and they had to approve the amount of the fees, for otherwise it was an end run on the class action process. Unfortunately, the First Circuit did not agree, and in a case called Duhane against Hancock, they said that their objectors had no fiduciary responsibility to the class, that the lawyer only represents the objecting party, and there was no rule requiring class counsel or defense counsel to disclose anything or to approve anything, have the court approve anything. All counsel in that situation truly said they were representing their clients zealously, and that was surely true as to the frivolous objection, because it probably would have cost more to litigate and there would have been delays. As to the meritorious objection, I'm sure the defense counsel could say that they were representing the best interests of the clients, for after all, they'd gotten through a settlement that might be overturned, and they were perfectly happy with the settlement. And even as to class counsel, they undoubtedly believed that they were right, but they were not anxious to have the rightness of their opinion tested out in a higher court. And after all, who is ever sure of whether you're right or wrong? But if you examine the situation from the outside, those practices I suggest to you are clearly undesirable in many respects. If the objection is truly frivolous, what we are doing is sanctioning extortion by lawyers who are taking money for themselves and for their clients, to which, under the settlement applicable to everybody else, they are not entitled. And they're doing it because they're using the leverage of the class action. They are representing their clients zealously. They're doing a wonderful job for their clients and also a good job for themselves. And if the objection has merit, or has arguable merit, then if the Court of Appeals decides it has merit, then the people who are injured are members of the class who are being deprived of rights under the law to which they would otherwise be entitled. Now, we do not suggest that in situations like this that the answer is to forbid all of these additional payments. We only want a rather modest change to assure that the interests of third parties are taken care of, and that extortion does not allowed, and that valid objections go forth, and that the objectors, payments to the objectors and to their lawyers should be subject to the same requirements of disclosure and approval as payments to class counsel. That will not happen, of course, if zealous representation is the only criteria by which lawyers and courts act. The notion that something that other than zealous representation may be relevant is, contrary to what you may think from my prior remarks, not something that is totally foreign to our code of ethics as it is now. For example, it is plainly unethical for a lawyer to allow a witness or a client to lie under oath in a case in court. There are, of course, lots of questions as to whether the rule applies, whether the lawyer knows the client is lying or not. But there is no question as to the basic proposition that a lawyer acts unethically by allowing a client to lie. But surely, for a defendant in a criminal case, where that person's life may actually be at stake, a lie may be the only chance for acquittal. And yet the rules clearly do not allow a lawyer to operate in a way to aid the client when the client wishes to lie. Why should that be? And that's because, I submit, that our rules recognize that in some situations there are higher values than simply zealous representation of the interest of the client. That the system depends on truth and the lawyers not cooperating in bringing deliberate falsehoods into the courtroom. Could you imagine a system in which truth has a lesser role? Defendant would not be subject to the rule about lies in the courtroom. Is that an unthinkable situation? I think not. Some would say it's not followed now anyway. Lawyers routinely violate it, although they pretend not to do so. My point is not whether it's a desirable or an undesirable rule, but to recognize that in both situations we have a trade-off between zealous representation on the one hand and other values in our society which we also recognize have an important role. And the balance has simply come out differently. Or take the obligation of a lawyer in litigation or in bargaining regarding the disclosure of facts. A lawyer is not allowed to mislead in litigation or in negotiation. There is, of course, no obligation of the lawyer to volunteer facts even when the other side appears to be operating under a misapprehension as to the state of the facts. The lawyer simply has no as an obligation not to affirmatively mislead. Unless, of course, the lawyer is a prosecutor in a criminal case in which laws like the Jenks Act and the Supreme Court decision in Brady tell that the prosecutor has an affirmative obligation to bring forward additional facts that may exonerate the defendant. So rules say silence is okay even in the face of an obvious mistake. In the context of litigation, that's probably a defensible rule. After all, both sides have full access to discovery. They can put witnesses under oath and ask for documents. And so if you don't ask, then perhaps it's your fault. That, of course, is not true in our bargaining situation, whether you're buying a house or selling a car or whatever else you are doing. The issue about disclosure is the same as if there was in litigation, but the trade-off, again, is a little bit different. Interestingly, the ethical rules take a little different approach on questions of law. The different balance is struck because there is in our code an affirmative obligation of lawyers to call to the attention of the court, even when the adversary does not do it, of controlling precedent in the district, in the court in which you are litigating the case, adverse to the interest of the lawyer. Why should that be the case? Why should you have to disclose law when you have no affirmative obligation to disclose facts? It surely cannot be based upon the difficulty in discovering the information. After all, every lawyer has access to the same law books, or I should now say Lexis and Nexus and Westlaw, that every other lawyer has access to. So in theory, anyone could find out the law, but anyone could not find out the facts because the access is not equal in those situations. And why should it only be controlling precedent that a lawyer has to disclose? And what if it's not controlling in this district, but there is very strong precedent in other states that would surely influence the judge's thinking? Yet there's no obligation to disclose that as well. Perhaps the rule can be justified on the grounds that, after all, the courts are making the law. They have an obligation to get the law right, and they can't do that unless they have all of the law in front of them. One could say the same thing about deciding lawsuits. The obligation is to get it right, and the only way to get it right is to have all of the facts in front. I am not here to attack, or for that matter, defend either of those two sets of rules. But I offer them here to you to point out that not even all of our current rules say that zealous representation is the only value that we as lawyers must follow. Let me return for a moment to the rules on confidentiality, which are, as I pointed out before, very strict. There is one exception which I haven't mentioned to you before. It doesn't apply, confidentiality rules don't apply if there's a litigation between a lawyer and a client and the issue is fees. And the result is that in litigation between a lawyer and a client, the lawyer is not forbidden and permitted to make disclosures in connection with that lawsuit that the lawyer would otherwise be forbidden from making. And so there is the real possibility that if you're the lawyer for someone in a divorce situation, that the potential is there to spill all of the nasty secrets that you as the lawyer have learned as a means of assuring that you get paid in full. Now, the courts may well, and in some cases, have construed this rule to apply to disclosures only to the extent necessary so that you can collect your fees. And the question is not whether this is a good rule or a bad rule or whether it was written by lawyers for the benefit of lawyers, but simply to observe once again that we recognize that our system has other values besides zealous representation. My final set of examples deal not with the code of ethics but with admission rules for the bar. And they illustrate how lawyers can sometimes put the interests of clients, albeit not directly their own clients, in second place. That is, at least in the view of some people. There are a long history of rules requiring residence for bar admission in the United States. My colleague John Sims and others brought and eventually won a great many of these cases, and finally the Supreme Court declared that these rules were unconstitutional under the Privileges and Immunities Clause. The claim was made that these rules were intended to protect the clients from lawyers who were not qualified to practice law. But most of us who looked at the rules saw that they were principally there to prevent lawyers from other states from coming in and poaching on the business of the lawyers who resided in the state where the client needed the legal services. It still is not, today residence requirements are outlawed, so there's another means of getting at this same kind of worry, and that is requiring lawyers to take bar exams after they've been in practice for 10, 20, or 30 years, and no waivers on admission of any kind. It will come as no surprise to many of you that two of the states that have been most vehement on this issue are Florida and California, where many northern lawyers have decided that they would like to retire, not completely retire, but retire and do a little law practice on the side. But they've become rather discouraged when they find that after 30 years they've got to go back and take a 2.5-day bar exam, not simply boning up on community property in California. And so this rule, of course, is again one that's been offered in the name of consumer protection, but in my judgment has a considerable element of self-protection in it as well. Surprisingly, I read recently that things may be changing in California. A bill was passed in the California legislature requiring the California Supreme Court to review the situation. And who should be behind at least a major element of this, but a group called the American Corporate Counsel Association, made up of lawyers. You say to yourself, why are they all upset about it? Well, when you think about it for a second, these are lawyers, but they're really clients. They are hiring lawyers, and they're suddenly finding out that they're running up against obstacles. They want to transfer their lawyers from one office to another, and they suddenly find that the lawyer has got to take a bar exam, and that is a major impediment because it costs money in terms of studying time and everything else to get me away from their work. And so this group was behind it, and we will have to see whether California changes its admission requirements, or whether, if they don't, the California legislature do what they were threatening to do, which was actually to propose a change in these bar admission requirements, and if so, whether the California Supreme Court might follow what the Arizona Supreme Court did in a comparable situation and declare the legislature to have acted in violation of separation of powers, because only the court can control the activities of lawyers. There are many more examples that I could give from the ethics and other rules governing the conduct of lawyers that illustrate my point that these judgments in all of these situations involve a series of trade-offs between competing interests. And I want to be clear that I don't think that even all, let alone necessarily any of the judgments are wrong. But I do think that there are clearly interests at stake besides those of the bar and the courts and the zealous representation of clients. But it is equally clear that the interests of these other parties are not adequately represented in the course of the process by which the rules that we lawyers live under are recommended and the rules are changed. And they are surely not involved in any way in having persons who are not lawyers participate in the decisions as to which rules are going to be adopted at all. And if we had outside participation, meaningful outside participation, in my view, we would have a rather different debate about many of the rules under which we lawyers live, and perhaps have a different outcome. What do I think we should do about this? We need to find another way, a better way, to get non-lawyers into the process. We lawyers are wonderful. We refer to everybody else in the universe as non-lawyers. When the guy comes to my house to fix my plugs or repair my sink, he doesn't refer to me as a non-plumber or a non-electrician, although he surely should, for I am far less qualified than he is to practice law. So we need to find ways to get the public involved. We need to have persons who are not members of the bar sit on bar boards. We need to give them votes and not simply the right to speak. That the ethics committee, including the right to vote, should be composed of lawyers as well as persons who are not members of the bar. And if there's a different committee that writes the rules than the ethics committee which interprets the rules, then non-lawyers ought to be on those committees as well. We need input from consumers, business, and individuals. We need input from lawyers. Is too important to be left to lawyers, especially when lawyers are writing rules that affect third parties. Thank you very much.
Thank you, Alan Morrison, for your stimulating remarks, and I'm also thrilled that I have finally, after all these years of law school and being a lawyer, actually met an officious intermeddler, as you describe yourself. Mr. Morrison has graciously agreed to stay a while and answer any questions you may have. I think people can be heard from the back of the room. The acoustics are pretty good in here, so feel free. Yes, Chief Justice Coffin.
Apropos of nothing except your introduction, was curious, considering your work as a lawyer advertising, are you see positive results, or is it sort of a mixed blessing at the moment?
Well, I think the answer is, if I had to choose the old system under which nobody got any information about lawyers, what they could do, what kind of work they did, what they charged, and the current system under which, at least on some television stations at some time, most people get a lot more I'm not even sure it's information. They hear a lot more about lawyers than they probably want to hear, and it's very useful. It's clear to me that the current system is better than the old one. Could it be better? Yes. I don't watch a lot of television, so I'm not sure that I'm the right person to make this judgment. My sense is that lawyer ads are getting less annoying than they used to be, largely because the annoying ads don't work. But there are surely some of them around, and people will be annoyed by other things. We had a case once involving a lawyer who was looking for plaintiffs in Dalcon-Shield cases, and he put a photograph, a drawing of a Dalcon-Shield in an advertisement. And the Ohio bar came after him for, I think the official charge was using pictures in advertisements and whatever it was, they didn't want him doing it. And the evidence in the record was quite clear that there were hundreds of women who did not know they had a Dalcon-Shield because they had no idea what a Dalcon-Shield was, but they remember what that little funny-looking thing was, and they were able to get access to legal services to help them in the case, which they simply would not have been able to do without that advertising. So I think, yes, there are some abuses is a little stronger than I would put it, but there are some unpleasant or maybe unsavory things about some lawyer advertising. But I think I'm pleased with the result. We have more competition. That is, we now have people advertising prices. The legal clinics could never have gotten started if the advertising rules, ultimately, as you certainly know, the first case that went to the court involved legal clinics, which was a wonderful thing for it to happen, because it made it so much easier. Well, it was even 5-4 in that situation, but it made it possible for the court to rule that.
I had a question about the example of the lawyer who didn't tell about the location of the dead bodies and the community outrage about that. It seems that there was outrage that the lawyer did not report it or did not have a duty to report it. But it seems that that outrage would have to also be based on the idea that people who weren't lawyers, who knew about that kind of thing, would have some kind of a legal duty to report that. But there's nothing that I know of where there's sort of a general duty that people have to report on bad things. And so is it fair to say, well, lawyers should have a duty to report on bad things when they hear about them, when people in the street don't have such a duty?
I think the outrage was over the notion that the lawyer couldn't report it, not that the lawyer had to report it. That the lawyer said, the story is kind of complicated, but at one point the lawyers, unwisely in my judgment, started to talk after the client had talked. They got themselves in more trouble than they had if they just kept silent and said, I did what I had to do. They said, I wanted to do it. And they couldn't, and everybody said, how can that be? Can it be that here, that we have rules for lawyers which forbid them from being human beings? They can't tell a family that wants to know whether their child is alive or dead, that the child is dead so they can get on with their lives and forget about the punishment and forget about criminality. They simply wanted to know. And the reaction, they took it out on these lawyers, but that's because I don't think they understood that it was not the lawyers themselves, but it was the system under which the lawyers operated that caused them to do that.
I'd be interested in your thoughts, either personally or how you think it would be handled in D.C. We have an ethics issue that's developed in Maine over the last 10 years. We have sort of a split in the courts or between the federal and state courts on the inadvertent disclosure or the inadvertent facts situation, and whether, as a lawyer, if you were the recipient of inadvertently produced information, whether it's a confidence or a secret, do you have to inform your client that you received it before you decide whether to give it back or not, or you can go to court to get the court to decide whether to give it back or not. Because in Maine, we don't have the word zealously represent.
Zealously is actually not in the rule anymore in most places, but
most lawyers think it's
still there, and it's treated that way. The notion of loyalty and fidelity to the interests of the clients, even without zealously, I don't think the adjective adds much. It was there, and people used to hang their hat on it. Obviously, the issue is if you represent your client to the best of your ability, if you're loyal to your client, you want to get the facts, and the same thing is true if somebody hands you a document in a deposition that turns out to be the lawyer's notes as opposed to something else, the same problem arises. It happens more with fax machines, and I imagine it's probably going to happen with emails, where you you hit the return to your client and it goes to the other lawyer. We had that in another context, which I won't go into, but it turned out to be all right in the end, but you know, the email is not an unmixed blessing in those kind of situations. I don't know, I have not had the actual occasion to look up the law. I think the law in the district is that you're supposed to give it back. If your client found out about your client would probably be very unhappy. Again, I think that the answer is there's a trade-off. If you're representing your client to the best of the ability, surely you don't let somebody who says, oops, I didn't mean to ask that question in the deposition, or I didn't mean to strike this witness, this juror from the jury pool, I wanted to reserve it. Oh, that's okay, you can go back and do it again. Your client would not allow you to do that in most cases. But the issue also arises of lawyers' courtesies and what we do and don't do and what we allow our clients to tell us we can and cannot do. Again, I think these are all trade-offs, and there's no clearly right answer in any of those situations.
Bill?
Your ultimate recommendations, I understand, focus in large part on the form that the tribunals and the court give for non-lawyers considering these issues. Given that the court, in many areas of public policy, balances and makes those trade-offs in public policy, when it hears only from lawyers on behalf of people policies, is it more an issue of form, or would perhaps maybe progress be made in this area? Courts simply more consciously recognize that there are competing goals when matters affecting lawyers or courts.
Well, let me say two things. First, I think the courts in the last 25 years have become more aware that there are value judgments in the rules, that it's not simply don't lie, don't steal, and don't cheat. The ethical rules have some value judgments and trade-offs. I'm not sure that and one can't speak generally about every court, obviously. The issue about how much they focus on the rules and on the trade-offs that are inherent in them. These rules often come up in large bunches of them. We're about to have another Ethics 2000 or whatever the ABA is going to come forward with. There'll be massive rule changes. Courts are busy. Their primary job is deciding cases, not issuing rules. They take their responsibility seriously. But unless somebody is there calling to their attention, look, this is a trade-off here. Is this the kind of trade-off that you want to make? I think it's less likely that they'll focus on it. And if they don't focus on it, they're going to do what the bar has been doing. My belief is that form and process do matter, and that arguments are presented in an adversary or in a more broadly communitarian context are more likely to see different sides of the issue presented. All of us, I think, are in one way or other set in our ways. We've been doing things for a long time, and when somebody says to you, you know, this is something that you believe in and you've been doing, but maybe it doesn't make any sense. I give the example of the one thing I didn't talk about was the unauthorized practice of law involving situations in which for many, many years the bar has said that some of us believe that some of this was economic protectionism, but it's not economic protectionism completely. There's a healthy dose of paternalism as well, that we know what's best for the clients and we're taking care of the clients. In many of the cases that our office has been involved in, the question was not whether the client was going to go to a lawyer, because there was simply no lawyer available to do the work, or in some cases there was no the client had no money to afford to pay for a lawyer, and legal services simply couldn't take on these particular cases. So if you had a legal secretary helping out with a bankruptcy or with a divorce or something like that, that was some service. And I used to put it this way: the bar insisted that the clients drive Cadillacs when all they wanted to do was have a bicycle or a Studebaker to take them along. And if you ask clients, would you rather have nobody to help you out or somebody who is not a lawyer but who knows something about this, I think most clients would answer, give me some help. Give me a small crutch. It may not be what you have. Although there are some arguments that some of these legal secretaries and bankruptcy specialists know a lot more about the lawyers who the clients are likely to get, but that's another story. So I do think it matters, and if the question is put that way, if you have a public input from people who have different perspectives, that is, these providers or the clients, I think you will get rather different sets of answers than you do now. Not in all cases, but surely in some of them. Maybe you won't, but I think people would have more confidence, even if the result came out the same, that we're getting a more broad-based input into the decisional process.
Welcome back, and I think this will have to be our last question, because I feel the museum leaves us out of here. Yes?
I would suspect, based on some of your comments, that you may have something to say about multidisciplinary practices. Is this an area of the practice of law where the rules should be relaxed if it's the public's perception that NDPs may be able to serve their needs better than traditional legal representation?
I don't know the answer to the question of whether lawyers and accountants or lawyers and lobbyists should be able to get together in their own firms. There clearly are some interests in confidentiality and decision-making in particular cases that lawyers have to keep separate. Whether the rules that have been suggested would be adequate to protect that, I don't know. The only thing I do know is that if the ultimate choice is made by lawyers alone, or judges, that people are going to have a lot less confidence in the decisional process, that the right and fair result came out, than if others are involved in the process. I'm not too worried about the big 8, or I guess it's probably now the big 4 accounting firms, protecting themselves in terms of making their views known. But whether in the end it'll matter if you've got nothing but lawyers deciding the outcome, lawyers who are judges, no disrespect to the many fine members of the judiciary in the room and in my host, although as a judge in the First Circuit, they don't make too many rules that govern the conduct of lawyers. I don't know, but that's surely another example of an issue in which the effects of third parties, and I'm not just talking about the accounting firms, I'm talking about the people who want service, the organizations and individuals who would like the opportunity to go one place and have many of their needs taken care of, and the question decided not by what kind of shingle you have on the door, but who is in the best position to solve the particular problem that is there before it. The clients do matter, besides the warring combatants of the accountants and the lawyers.
Well, our thanks to Alan Morrison, to Judge Coffin, and to all of you here tonight. I want to take a few minutes, just a minute, to thank someone here behind the scenes, my talented, creative assistant, Heather Delios, who was so instrumental in making tonight such a great success. And I'd also like to thank her husband, I don't know where he is, Michael Delios, who is sort of the prince behind the throne and who provides all sorts of behind-the-scenes help. I'm delighted that you've all come. Our Coffin lecture next year is on October 11th, 2001, when our 10th Coffin lecturer will be Professor Hai Feldblum, professor at law at Georgetown, civil rights activist, and founder and director of the Legislation Clinic at Georgetown, and a former Coffin clerk. So thank you all for coming. We'll see you next year.